Captured on CCTV, 3 teenagers are seen running away from Irvine Beach in North Ayrshire after they'd stabbed 16-year-old Kayden Moy to death. Having left the scene, the 3 appear to hug and congratulate each other on what they'd done. They are 18-year-old Turley and 19-year-old Jay Stewart, who were today each sentenced to a minimum of 16 years in prison, and a 15-year-old, who can't be named for legal reasons, given a 14-year minimum sentence.
After the attack, consistent with the jury's verdict that you didn't care whether Kayden lived or died, you appeared at times to celebrate what you had done.
Kayden had been completing an apprenticeship as a painter and decorator and dreamed of one day starting his own business. After his death in May last year, hundreds gathered with Kayden's family and friends close to the place where he was killed to release green balloons in celebration of his life. Outside court today, Kayden's father urged people to remember his son for how he lived, not for how he died.
Today, the 3 boys responsible for taking our son Kayden's life has finally been sentenced. While today's outcome brings a measure of justice, it does not bring peace. It does not bring our son back. Kayden was more than a name in the courtroom or a headline in the news. He was our son. He was loved beyond words and had his whole life ahead of him. Every birthday, every family gathering, every milestone from now on will be a reminder that he should be here with us. That the sentence, that is the life sentence our family has been given. The choices made that day have devastated our family forever. We hope today's sentence sends a clear message that violence and devastation... We hope today's sentence sends a clear message that violence has a devastating and irreversible consequences. One moment of violence has destroyed so many lives, and no family should ever have to endure the pain that we now live with every day.
The court heard that the teenagers attacked Kayden because he belonged to the Himshi group, a rival of their own group, the Murray Boys. Delivering all 3 life sentences at the High Court in Glasgow, Judge Lord Scott said Kayden had been unarmed and was stabbed when he slipped and fell, trying to run away.
Turley, you have pled guilty to the murder of Kayden Moy on 17th May 2025, just over 14 months ago. In doing so, consistent with the evidence at trial, you accepted that it was you who stabbed Kayden Moy, either wickedly intending to kill him or assaulting and fatally wounding him with wicked recklessness as to whether he lived or died. That is, that you showed complete indifference as to whether he lived or died. Jay Stewart and AB, while neither of you was directly involved in the physical act of stabbing Kayden Moy, you were both convicted of his murder. The jury therefore accepted that you acted together with Turley with the joint purpose of killing Kayden Moy, or one of his group, or at the very least in a joint purpose which involved the use of serious violence, carrying an obvious or foreseeable risk that someone in his group would be killed. Although your names are in a different order in the indictment, when I deal with you individually, I will continue to address you in the order Turley, Jay Stewart and AB. Before that, however, there is an important matter I must address. There is in this case a victim impact statement prepared by Kayden Moy's mother and father on behalf of them and Kayden's 2 younger brothers, as well as other family and friends. This powerful statement helps me to understand the unspeakable loss and harm that you have caused to that family. Kayden's parents described the continuing daily impact on them in many different ways of the traumatic loss of a 16-year-old boy who was at the centre of their family. They described their acute awareness of his permanent absence. They described Kayden's dreams, ambitions and efforts towards his ambition of setting up his own painting and decorating company. That and more stolen from them in a few short minutes of senseless violence. As the trial focused only on the last few hours, minutes and seconds of Kayden's life, it is appropriate to quote more of what his loving parents say about him. Kayden was only 16 years old. He was an amazing boy who lit up every room he walked into. His laugh was infectious, his smile unforgettable, and his presence brought happiness to everyone around him. He was caring, respectful, well-mannered, and had a maturity beyond his years. Kayden had the biggest heart. He was kind, loyal, and thoughtful, always ready to help anyone who needed him. He had a special way of making people feel comfortable and valued. Everyone who met him loved him. He made friends easily and was deeply loved by his family, his friends, and everyone fortunate enough to know him. Since the day Kayden was taken from us, our lives have completely fallen apart. We are devastated beyond words. The pain of losing a child is something no parent should ever have to endure. There are no words that can truly describe the emptiness and heartbreak we now live with. It is a constant pain that never leaves us. As his parents, we carry an unimaginable burden. The shock, trauma, and grief affect every part of our lives. There is an empty chair at family gatherings, an empty bedroom in our home, and an emptiness in our hearts that can never be filled. We do not simply miss Kayden on special occasions, we miss him every minute of every day. No sentence imposed by this court can bring our son back or ease the pain. Nothing can undo the devastation that has been caused. But we ask the court to remember, when considering your punishment years, that this was not just a life taken. This was our son, a 16-year-old boy with a bright future, a loving family, and dreams that deserved the chance to become reality. Kayden mattered. He was loved beyond measure, and he will be missed for the rest of our lives. It is obvious that there has been a massive impact on that family. Nothing said or done here today, and no sentence I impose will be enough to help Kayden's family with the devastating and traumatic loss of a much-loved son, brother, grandson, nephew, cousin, and friend to many. The punishment parts I must impose are in no way a measure of his life and of the enormous harm of what you did. I'm grateful to Kayden's parents for explaining their loss to me by telling me a little about their son. I'm grateful to them too for the quiet, dignified and respectful way they conducted themselves as they attended every day of the trial, despite the incredible difficulty of sitting and listening to distressing evidence about their son's murder. Before passing sentence, I asked for a Justice Social Work report on each of you. This was with a view to finding out more about your background and any other relevant information before passing a life sentence, not least because of your young ages. I wanted to see these reports, which I now have, despite the fact that I must pass a life sentence on each of you. In your case, Turley, I also have a detailed psychological report dated 15th May, prepared by a clinical psychologist. As you all know, I must set a punishment part for each of you, which is the minimum period of time you will have to serve in these life sentences. And the reports have assisted me in determining that period. Turley, the report in your case has been prepared with input from a number of mental health and social work professionals. It explains your use of cocaine and alcohol in the days leading up to and just before the murder. You have given in the report an unconvincing and self-serving account of how you and your two co-accused came to travel to Irvine Beach. Your account of events immediately before the murder is inconsistent with much of the evidence. In particular, the evidence suggested that Kayden Moy had no weapon or indeed anything in his hand. Your movement towards him was confrontational, completely unnecessary, and in no way in self-defence. Kayden seemed to slip, and you stabbed him as he scrambled to escape. He was vulnerable at that point, offering no threat to you. It seems on the evidence that you may have had no particular target in mind. Your intention, shared with your co-accused, was to engage in an armed attack on a member of the Himshire group. Kayden just happened to become your victim because he slipped and fell. You described the stabbing as a blur, no doubt at least in part due to intoxication with cocaine and alcohol, but perhaps also because you've not yet truly come to terms with the enormity and finality of what you have done. I note that despite admitting it to the author of the Justice Social Work report, you denied any drug use when you spoke to Dr. Gleeson. That suggests an unwillingness to be frank, at least at times. You were at least candid enough to accept in speaking with Dr. Gleeson that what could be seen in the video footage in the case was not how you remembered things regarding what Kayden Moy did, reinforcing the idea that you have rewritten some of the events, perhaps to try and come out of them better or to try to deal with what you did. Your account of what happened after the murder is also at odds, to some extent, with the evidence at trial. You accept taking a knife with you to the beach, although claim not to have done so with the intention of causing harm. You have minimised the planning involved in the incident, although accept that otherwise you take responsibility for your actions. You have described feelings of remorse and guilt. Indeed, Dr. Gleeson does describe you as being saturated with remorse, although more work is required on this, and your insight more generally into behaviour, in particular around the habitual carrying of knives, which you appear by experience to have come to consider normal. The report gives me details about adverse childhood experiences, including the traumatic death of your father when you were only 11. You witnessed and experienced domestic abuse and violence, and due to concerns for you and your family, there was social work involvement from the time you were born, which continued until the termination of a compulsory supervision order as you approached the age of 18. Related to this, I note the very recent diagnosis of fetal alcohol spectrum disorder and the possible impairment it causes in a number of areas, which include executive functioning, and that in turn includes impulse control and hyperactivity. You meet the description of borderline intellectual functioning. Dr. Gleeson says you are reactive, impulsive, and experience sudden and extreme shifts in emotion. She addresses all of this in detail in her report, which explains, at least in part, how you may have been hypervigilant to threat, albeit that omits the role played by significant drug use that day and the fact that this was a planned act of violence. The report states the nature of Mr. Turley's offending appears to be ingrained in the context of youth violence and conflict. Mr. Turley's behaviour during the index offence appears to have elements of being reckless and deliberate. The young team culture of territoriality and habitual carrying of weapons appear to be examples of extremely negative peer behaviour and pressure, which you considered normal until your remand in custody gave you some time to reflect. And the past year has seen you develop some insight into this behaviour. You're assessed as presenting with the maximum level of risk and need, requiring a high level of support and intervention, although I leave the question of risk out of account, as that will be a matter for the parole board to assess in due course. The report recognises some of the wider effects of what you did. The harm caused by the index offence has impacted the community as a whole. Present at the beach were a number of young people aged 17 and 18. It is likely that witnessing such a violent attack will have a lasting negative impact on the community in general. It seems that there is much which can be done while you're in custody to try to address some of the factors that contributed to what you did and where you find yourself at the age of only 18. Dr. Gleeson suggests that group work may be of particular benefit in your case at some point in the future. It is to be hoped that you accept some of the help and support which is available, which can only be in the interests of society as a whole, as well as yours. Today, in addition to addressing these other matters, Mr. Stewart has emphasised your plea of guilty, which is still unusual in cases of murder. I will give that some weight, albeit the plea came very late in the day. The offer to plead guilty to culpable homicide had no real practical or utilitarian value. Jay Stewart, significantly in your case, you have previous convictions, as well as matters dealt with by the children's hearings. You have 2 convictions, one for various charges including possession of a knife in a public place and possession of a metal pole as part of threatening and abusive behaviour. At the time of the murder, you were on a structured deferred sentence for that case, which no doubt included a condition that you be of good behaviour. In fact, you'd been placed on that deferred sentence only 2 months earlier. While that matter was dealt with in summary complaint, your other conviction on 22nd April 2025 was dealt with on indictment and was for possession of a machete in a public place. You were made subject to a community payback order in that case just 4 days before your involvement in Kayden Moy's murder. Your previous convictions are aggravations and have a bearing on the culpability or blame to be attached to you in this case. The report in your case has been prepared with input from a number of social work and other professionals, as well as your mother. It indicates your capacity for maturity and emotional intelligence, although sounds warnings around your entrenched involvement in gang culture. You explain to the author that some of the codes of your gang include loyalty to other members, protecting your territory, and dominance over other rival groups, particularly in the East Kilbride area. Information gathered indicates violent acts, use of weapons and, broadly speaking, antisocial behaviour was acceptable and encouraged. You also gave the impression that any perceived threat to the image or safety of those within the gang would lead to acts of aggression, with or without weapons, ensuring that a sense of mastery and your desired self-image was maintained. You also said that this was a gang-related incident. You described your life at the time as being a shambles with use of drink and drugs and a general pattern of chaos. You accept being heavily intoxicated that day through the use of alcohol and cocaine. Although it makes no sense and is also contrary to some of the evidence, you maintain that your admitted possession of a baton was coincidental to a trip to Irvine with friends on a sunny day, claiming, without any plausibility, that it was unrelated to the presence there of rival group members. Although your recollection of events is particularly poor due to intoxication, you claim to have had memories triggered in court by some of the video evidence. The memories you claim have returned are all favourable to you, suggesting innocence of the charge, something clearly rejected by the jury when they convicted you. Rather than reflecting on your own proven involvement, you've sought to deflect to what others may or may not have done. I reject your unconvincing efforts to escape responsibility, although if there was anything in them, they might be thought to suggest a reason for targeting Kayden Moy, something that was absent in the evidence at trial. The most you seem to accept, despite having no substantial or convincing memory of what happened, is that you acted like a dafty. Your involvement went well beyond that limited and self-serving suggestion. You were not merely there and behaving badly or daftly in some stupid minor manner. The jury accepted that it had been proved that you were part of a plan to attack one of the Himshie group with weapons and in a joint purpose which involved the use of serious violence, carrying an obvious or foreseeable risk that someone would be killed. This ties in with your strong sense of belonging and loyalty to the Murray group, in which you considered yourself a top man who couldn't be seen to back down for fear of being seen as weak and losing credibility with the group, who you considered as being like family to you. The report tells me that you too have suffered adverse childhood experiences, suggesting that it is possible that these may have contributed to a numbing of emotional responsiveness and feelings of detachment in terms of his violent behaviour. These included a traumatic bereavement at the age of 4. You too witnessed domestic abuse and violence, although failed, it seems, to participate in counselling for this which was offered. You too had social work involvement and were made subject to compulsory home supervision, home supervision order due to concerns about risk to the public. Subsequently, you were placed on the Child Protection Register, partly through placing yourself at risk, and later due to emotional harm caused to you by parental neglect. Further supervision was tried from 2021 to 2024, although you persistently returned to your gang and criminal behaviour. When you were only 15, you were stabbed while intoxicated in gang-related violence and reprisal. It seems that you were lucky not to be more seriously injured. Head injuries and other attacks are also noted. Given your own experience, you should have known not to become involved in incidents with weapons and violence. You've been referred to psychiatry within the prison and you await an appointment and assessment. I'm told that you've remained drug-free while in custody. You've engaged well in the Positive Choices course in Polmont and otherwise generally engaged in positive activities there, resulting in you recently securing a position as a hall pass man. It is to be hoped that you continue to make the most of such opportunities and that you avoid any more misconduct reports beyond the 2 already received for fighting and reckless endangerment of others. The report explains issues with your physical and mental health, with the latter no doubt involved in your heavy drug use from an early age. You too are assessed as scoring in the maximum risk category level, although I leave that out of account as I must, risk being a matter for the parole board. Regarding violence in your victims, the report states, typically, Mr. Stewart will perceive them to have threatened or in some way disrespected him or members of his gang, to which he has responded with disproportionate and serious violence. The nature of his violence appears to have been planned and reactive. And the report concludes, Mr. Stewart's violent behaviour resulted in positive reinforcement including loyalty, status and a sense of worth. His problematic cognitions and attitudes allowed him to justify acts of violence, and a level of moral disengagement allowed the behaviour to continue without experiencing guilt. It seems that there is much which can be done in this and other areas while you're in custody to try to address some of the factors that contributed to what you did and where you find yourself at the age of 19. Today, in addition to the matters I've mentioned, Mr Finlay has emphasised that you played no direct physical role in the attack on Kayden Moy. AB, the report in your case has been prepared with input from a number of social work and other professionals. It tells me that you still do not understand why you were found guilty. You too claim to have a poor recollection of events due to intoxication through the consumption of alcohol and ecstasy. You have offered the author of the report a sanitised version of events and omitted anything which happened in the aftermath. It is said in the report that you have demonstrated at one point no and at one point little remorse, although at least in part this may be due to your age and inability to process what you did. You appear to have shown some victim empathy as well as concern for yourself and your own family. You've shown what seem to be the beginnings of insight and reflection. It is said that you may benefit from psychological interventions to assist you to better understand your thoughts, emotions and behaviour during the events of the index offence. You too witnessed domestic abuse and had social work involvement out of concern for you. The report details adverse childhood experiences. You were placed on a compulsory supervision order in January 2025. A significant improvement in your education is reported since you were placed in secure care. Physical and mental health issues are described, and you may be assessed for ADHD, anxiety and post-traumatic stress disorder. The report states, evidence demonstrates that cumulative adverse childhood experiences can impair emotional regulation, decision-making and impulse control, increasing vulnerability to risk-taking behaviours, association with antisocial peers and offending, suggesting that your behaviours may be better understood as adaptive responses to prolonged adversity rather than solely as deliberate misconduct. Further support, assessments and interventions are indicated while you're in custody to build on the protective factors identified in the report. Specific areas of possible work are identified as well. You will remain in the present establishment until you are 19, when you'll be transferred to Pullman. Today, in addition to what I've mentioned, Mr Duguid has emphasised that you played no direct physical role in the attack on Kayden Moy. I've considered, in respect of all of you, all that is said in the reports and all that has been said on your behalf by your counsel. Your counsel have said all that can be said for each of you. I emphasise that being intoxicated or under the influence of drink and drugs, as you all seem to have been, is no excuse whatsoever. Those who commit crimes while intoxicated are just as responsible as a matter of law as those who are entirely sober. The three of you travelled to Irvine armed and intent on reprisal for some slight hurt caused to someone associated with your group. Two of you took weapons, including, in the case of Turley, the knife with which Kayden Moy was stabbed and murdered. Kayden Moy's death was pointless and unnecessary. Your victim could have been any one of the Himshire group, but Kayden was the one who slipped and fell. After the attack, consistent with the jury's verdict that you didn't care whether Kayden lived or died, you appeared at times to celebrate what you had done. Despite claims that intoxication has robbed you of any memory of what you did, with considerable presence of mind in the aftermath, you sought to conceal your involvement in this appalling crime in a manner also consistent with this having been a planned attack. The sentence for murder is prescribed by law and is a life sentence. Turley, you are 18 now and were 17 at the time. Jay Stewart, you're 19 now and were 17 at the time. AB, you're 15 now and you were 14 at the time. Accordingly, I have regard to the guidelines for the sentencing of young people which are relevant in your case and which require me to have rehabilitation as a primary consideration given the capacity for change in young people. They also state that the culpability of a young person will therefore generally be lower than that of an older person who is to be sentenced for the same or a similar offence. I bear in mind what is said in paragraphs 20 and 21 of those guidelines. Paragraph 20 states, however, the nature and duration of a sentence imposed on a young person should be different from that which might be imposed on an older person being sentenced for the same or a similar offence. Paragraph 21 states, if a custodial sentence is imposed on a young person, it should be shorter than that which would have been imposed on an older person for the same or a similar offence. In the case of AB, as mentioned in submissions by Mr Dogood, I also have regard to the UN Convention on the Rights of the Child as relevant to sentencing. In each case, your punishment parts are therefore less than they would have been had the guidelines not applied. Although it is worth repeating something said by the Appeal Court in Edinburgh 17 years ago. We agree that at the present time knife crime is a scourge in the Scottish community and that the court should be acting and be seen to be acting in a way which discourages the carrying of sharp weapons, the use of which may lead to needless deaths. Sentences which may cause individuals to think more carefully before arming themselves and which reflect public concern at such killings are appropriate. Today, knife crime remains a scourge in Scotland. This case suggests that there are young people who think it is normal and acceptable to go armed with weapons, in particular knives, to deal with minor disputes between different groups. The court will continue to make clear that it is not. Care needs to be taken when it comes to the sentencing of young people, but it is important that it is understood that there will be serious consequences for those who continue to carry and use knives. Call Turley, stand up. In the circumstances and as required by law, I sentence you to detention for life and specify a punishment part of 16 years. Had it not been for your plea of guilty, the period would have been 18 years. That is a reduction of a little over 10% for your plea of guilty. Your sentence will commence in a young offenders institution. It will run from 23rd May 2025. You should understand that this is not a sentence of 16 years detention. It is a life sentence. 16 years represents the minimum time you will have to serve before you can be considered for parole. Whether, and if so when, you're released will be a matter for the parole board to determine after that 16-year period and will be decided on the basis of the risk you're assessed to pose at that time. Sit down. Jay Stewart, stand up. In the circumstances and as required by law, I sentence you to detention for life and specify a punishment part of 16 years, which includes 6 months for breach of bail. Your sentence will commence in the Young Offenders Institution and will run from 20th May 2025. You too should understand that this is not a sentence of 16 years detention, it is a life sentence. 16 years represents the minimum time you will have to serve before you can be considered for parole. Whether, and if so when, your release will be a matter for the parole board to determine after that 16-year period and will be decided on the basis of the risk you're assessed to pose at that time. Sit down. AB, stand up. In the circumstances and as required by law, I sentence you to detention without limit of time in such place as Scottish ministers may direct and specify a punishment part of 14 years. The punishment part will run from 5th June 2025. You too should understand that this is not a sentence of 15 years detention, it is a life sentence. 14 years, sorry, it's not a sentence of 14 years detention. 14 years represents the minimum time you will have to serve before you can be considered for parole. Whether and if so when you are released will be a matter for the parole board to determine after that 14-year period has elapsed and will be decided on the basis of the risk you are assessed to pose at that time. That is all.